Plaintiff's attorney is Mr. Jones.
The witness?
The court.
I'm defense counsel Mr. Gould.
For the record, Mr. Smith, if you'll come forward to the witness stand and be sworn as a witness, step right to the front of the courtroom.
Watch your step. There's some wires there.
When you're there, please remain standing and raise your right hand, and the clerk will swear you in. Please state your name, spelling your last name.
Rodney Gale Smith, S-M-I-T-H.
Please be seated, Mr. Smith.
Mr. Smith.
Excuse me, Mr. Jones, is there a microphone or something? Because Mr. Smith is very soft-spoken. Please keep your voice up.
Mr. Smith, did you bring any documents with you this afternoon?
Yes, I did.
Would you hand those to me, please? Let me show these quickly to counsel. These are virtually identical to the immunity papers filed in the initial trial. As those are being examined, just some preliminary statements. I know you won't say very much until those are filed. They are immunity papers that have been reviewed by your attorney and yourself. Is that correct?
Yes, sir.
Excuse me, I don't think Mr. Smith knows what his attorney did.
Pardon me?
I don't know that Mr. Smith knows what his attorney did.
Is that an objection?
Yes, calling for hearsay.
Overruled.
And you indicated that you would not answer any questions that either myself or my investigator posed to you until these documents were signed by a superior court judge. Is that correct?
That is correct.
And in fact, you're not going to answer any further questions then, perhaps this one, until these are filed with the court. Is that right?
That is right.
Thank you. Your Honor, at this time, I would like to file with the court People's Petition Request Order requiring witness to answer questions pursuant to Penal Code Section 1324, and an order requiring this witness to answer those questions, which was signed by Judge Peter Allen Smith of this court on February 6th of this year.
Your Honor, could we approach the bench?
Are those for evidence or to be filed?
They're to be filed. And those documents are now filed?
Yes, they are.
Thank you. These documents are now filed. And you and I had an interview and a discussion regarding this case for the first time on September 6th, at which time...
Excuse me, Your Honor. I'm going to object to Mr. Jones leading the witness.
Let me explain for the members of the jury what a leading question is. A leading question is a question that suggests its answer, like, the sky was blue, wasn't it? As distinguished from what color was the sky. Leading questions are not permitted to your own witness, except under certain rigid circumstances. The reason for that is that if we permitted them, we'd hear, the sky was blue, wasn't it? Yes. You saw the ducks, didn't you? Yes. You fired the gun, didn't you? Yes. We'd never hear the testimony. We would just hear the responses of the witness. When you put a witness on, you can't use leading questions. However, when you're cross-examining the opponent's witness, then you can use leading statements, you did this, didn't you, type of questions, which are quite a powerful force in examination. Usually, we let them in at the start so we get the momentum up, but when it's a more critical point, we don't. I'll give you two more.
I just need the one. We first spoke regarding the circumstances of this case on September 6th.
Excuse me, Your Honor. I don't have a problem with that as a preliminary question, but it's not relevant when he spoke to him.
Overruled on the relevancy.
Your Honor, I had the wrong dates anyway. It was February 6th of 1990 that you and I first spoke about the circumstances of this case. Is that right?
Yes.
Had we ever spoken prior to that date?
Yes, but we didn't speak on the case, I don't believe.
Please try to keep your voice up. I'm going to stand back here, so try to project back to me. Why don't you tell me about the previous time we spoke? About when was that?
About 4 months ago, approximately 3-4 months ago.
Could you explain to the jury the circumstances under which you and I had occasion to meet?
I met in your office with my wife.
And who requested that meeting?
Excuse me, Your Honor. I would object on grounds of relevancy.
Overruled.
I believe at the time my wife suggested the meeting.
And what was the meeting, and what was discussed generally?
Excuse me, Your Honor. It calls for hearsay and relevancy.
The subject is not. Any statement made by anyone would be, but the subject of the meeting is not hearsay. Overruled in this respect.
What was discussed was...
Excuse me. I believe the witness is going to give a non-responsive answer.
No, he was asked what was discussed at the meeting. I believe he was about to tell us.
What was discussed was if I would testify in the future or not.
And did you pose to me certain requirements that you wanted before you would testify?
Yes, I did.
And what were you requesting?
Immunity, for one, a lighter sentence on my first contempt, and I believe I received nothing.
What was the last?
I didn't receive either.
I'm going to object, Your Honor, as non-responsive.
That part is not responsive to the question, so that should go out. He mentioned immunity as one element requested, and second, a lighter sentence as to his first contempt, and you can consider that.
I believe I also requested no time be served on my possible charge, if you could do anything with that.
What was my response to those requests?
Excuse me, Your Honor, I think Mr. Jones understands that that is calling for something beyond the scope of what's permissible here.
I don't see that at all, Your Honor. What's permissible is the jury be informed.
If Mr. Jones wants to take the stand.
This goes to his credibility. I'm going to overrule your objection.
Repeat the question.
What was my response to those requests that you made of me at that time?
You said you could not do anything to help me because it would look like you were trying to buy my testimony.
Your Honor, I'm going to object. That's a hearsay statement.
It's not received for the purpose of the truth of it. It's only to show the response that was made to his question.
Thank you, Your Honor. When we first met the meeting of September 6th, can you tell the jury whether or not there was a statement made pertaining to what I would guarantee to do in exchange for your cooperation?
Your Honor.
Same instruction with respect to that.
Also, Your Honor, is he referring to a meeting of September 6th?
Excuse me, did I say that again? It's February 6th. Thank you, counsel.
Okay, at that meeting you did say you would go to my sentencing on February 27th to tell the judge I did testify in this case.
Did I say I would do anything else for you?
Same objection, Your Honor.
Same instruction as to anything that Mr. Jones told Mr. Smith. It's not received for the truth of it, but only to give you an understanding of Mr. Smith's situation and what is working on his mind at the time he's making his decisions.
Okay, I believe you did say you could do nothing else for me under the law.
Can you tell the jury whether or not there was some statement made regarding any actions to, let me withdraw that. At the time that you and I, Mr. Thrasher, your attorney, Mr. Lindquist, the district attorney's investigator, were having the meeting.
I'm going to object, Your Honor. There's no evidence Mr. Thrasher and Mr. Lindquist were at the meeting.
Why don't you put that question again?
Who was present at the meeting on February 6th?
Tom Thrasher, myself, you, and Ted Lindquist.
And you've listened to the tape recording of that?
Objection, Your Honor. I think the time to stop leading is perhaps gone.
All right, sustained.
Can you tell the jury whether or not you have heard anything reflecting the contents of our discussion?
Excuse me, Your Honor. I object to the relevance of this now because the witness has not indicated that he doesn't remember something. So what difference would it make if he heard a tape recording of it?
Is the objection strictly on relevance?
It's ambiguity also, Your Honor.
Overruled on relevance and ambiguity.
Would you please ask the question again?
You may ask it be reread.
All right.
Do you understand the question?
No, I don't.
In addition to the 4 persons that were present at the time of the interview, did you notice whether or not there was any mechanical instrument there used for the purpose of recording our conversations?
Yes, there was a tape recorder there.
And can you tell the jury whether or not you have since heard the contents of our conversation placed on that tape?
Yes, I have.
And you've reviewed, can you tell the court and jury whether or not you have reviewed a transcript of that tape recording?
Yes, I did.
Can you tell the jury whether or not you attempted to edit and correct the contents of that transcript?
Yes, I did.
Now, what I was telling you pertaining to what I could provide and what I would not provide, do you recall at what point in our conversation that statement was made?
That was made prior to the recording.
I'm sorry, I didn't hear that.
It was made prior to recording.
If I understand your question correctly.
I'm going to object to that question as ambiguous. What statement was he referring to?
I agree. Why don't you restate the question to the witness?
At what stage of the interview, whether it was at the beginning, the middle, the end, in the context of that interview, did I make statements to you pertaining to what I could provide and what I could not provide?
I don't. That was after the tape recorder was turned on at the beginning of the interview.
At that particular time that you had the interview with all 4 of us present, where were you currently residing?
At the Marin County Honor Farm.
And why were you residing there at that time?
I was there for possession of cocaine.
And was this part of a sentence that you were serving?
Yes, it was.
How long was that sentence?
120 days.